It's complicated. No, not the analysis here on Legal AF, a new podcast, which is starring Asha and Renato. You don't want to miss Asha and Renato. They got the best gig in town. They've been together for a long time on a podcast. We have the now exclusive platform for Asha and Renato.
So Asha, what we've talked a little bit, we keep having these recurring themes in our podcast. We've talked in this podcast before about Humphrey's executor and this important Supreme Court decision from many decades ago. I think it was from the 1930s during the Roosevelt administration. Very kind of a key Supreme Court precedent that allowed for particular types of agencies that were bipartisan, had some measure of independence from the executive branch, like the FTC, the Federal Trade Commission, the FCC, the Federal Communications Commission, and of course, the Federal Reserve, which is sort of probably the most important of these. And essentially, it's a Supreme Court decision that allowed those agencies to have some measure of distance from the president. It sure looks like that decision is now on life support after a Supreme Court order that came out this week.
Right. And this also gets to a different issue. So we had the discussion about Humphrey's executor and sort of this whole thing that's been teed up for the court on the president's ability to fire the heads of these bipartisan agencies. Which, the Trump administration wants to do. But we also had a separate conversation with Steve Vladeck about something called the shadow docket.
Oh, yes. That's another. All these things keep coming from prior episodes and seeping into our podcast every week.
The shadow docket is essentially the emergency docket. So this is when an injunction is issued by a lower court, and then the government appeals and wants, or whichever losing party appeals and wants that injunction stayed, meaning they want the injunction lifted, essentially. And then it eventually gets to the Supreme Court, and the Supreme Court has to decide whether to stay an injunction or not. What Steve Vladeck has been chronicling is that there has been a pattern of the Supreme Court issuing stays or denying an issuance of stays that fundamentally change the law. And because it's being done in this emergency docket, it's done with these very short orders, which basically say we're issuing the stay or we're not issuing the stay, but without providing a lot of reasons. And so what Steve Vladeck has talked about is that what the Supreme Court has been doing is issuing these stays or declining to issue stays, but which effectively overturn precedent in the process, which you normally would not have done without a full briefing, an oral argument, and a full opinion. And that's effectively what's happened with this most recent Supreme Court decision, because it's not an opinion, it's not a merits-based opinion. This is an emergency docket order.
Right. And when you say a merits-based opinion, that's what you're talking about a moment ago, where, there's these briefs that are filed by both sides that are very lengthy and extensive and have all these citations, and all these other interested people across the country file what's called an amicus brief with their thoughts and views. And then everyone comes and there's this argument before the Supreme Court, and there's questions asked, and then there's a lengthy opinion that sort of puts it all in writing and lays it all out. So what we have is, and what we're referring to, once again, we're recording on Friday the 23rd. So this was yesterday. The Supreme Court came out with this basically 2-paragraph order saying, we're going to allow these, I think it's 3 people that Trump has fired off of these sort of bipartisan, quasi-independent boards to remain fired or to be fired while this is going on. And that effectively signals, I would say, that they've already thought about this issue and have concluded that when all of this briefing is done and the arguments have been heard, that they're going to overturn Humphrey's executor or extraordinarily limit it. And that's a big deal. And yes, it's true that technically speaking, maybe in this case, there's 6 votes because every one of the Republican appointees signed that order, agreed with that order, signed onto that order. But perhaps they would change their mind after hearing a oral argument. There have been times where an argument has impacted or amicus brief, for example, like by the military, talking about affirmative action that has impacted justices' votes.
Yeah. So just in terms of the facts of this case, this is actually two people. One is a member of the National Labor Relations Board, and another is a member of the Merit Systems Protection Board. And basically, Trump fired them. He fired them without cause. So they went to court and said, listen, under Humphrey's executor, we are on the boards of these bipartisan agencies. Trump cannot fire us without cause. And that those grounds are laid out in the statute that created these agencies. He doesn't meet any of them. And the lower courts basically said, you're right. We have this, 80, 90-year-old precedent that says that he can't do this. So the lower court forced Trump to actually reinstate them. And so that is what the Trump administration appealed. The Court of Appeals, I believe, upheld the lower court and said, nope, we're not changing anything. And then he went to the Supreme Court, and what the Supreme Court said is, as you said, one of the considerations, one of the factors that the court considers in issuing an injunction is the likelihood of success on the merits. And this is the piece that Renato is talking about, which is they basically said, these are agencies, engaging in executive functions. And the president, who has all of the executive power, has the power to hire and fire people in the executive branch. This is all going back to yet another thread that we've been talking about, Renato, the unitary executive theory. And so they're basically saying he's likely to succeed on the merits, so we're going to let him fire these people. And we'll hear the arguments later, but the only way he would succeed on the merits, Renato, is if they plan to overturn this precedent. And the dissent is basically calling them out on this. They're basically saying, you're more or less overturning this huge precedent that our civil servants have relied on for almost a century without any real hearing or argument.
Right. And that's exactly right. I think very well put, Asha. I mean, the bottom line here is, as you mentioned, this unitary executive theory, a lot of, I would say, Federalist Society, conservative legal scholars have had this view about the unitary executive. We've talked about this also on our podcast, although that was maybe from a season or two ago, so to speak, about some of the theories of the unitary executive. But the bottom line is these bodies that have existed, these agencies don't fit neatly into that category because they are meant to have a measure of independence from the executive. But I do think this is really, when it comes down to it, about the importance of process. And that's why I thought your comments about Steve Vladeck and what he's brought up about the shadow docket are so important. Because yes, it's fair to say that justices have often considered issues that are very close to the issues that are in a Supreme Court case, or perhaps they've considered those issues directly already and they have pre-existing views about a matter. But there is a reason we go through this process. And the process itself can influence a justice, can influence a justice to actually have a completely different view and flip a vote, but it also can influence the contours of their decision because the details do matter and they're important. And
sorry, go ahead.
No, the example I gave in the past that I thought was a famous one in the past is, affirmative action has essentially been overturned, another decision involving Harvard, but it took a while for that to occur. And there was a very famous case, I believe it was Grutter, which was the case against the University of Michigan, if I recall correctly, in which there was a lot of widespread speculation that the court was going to overturn affirmative action. And there was an important amicus brief from military leaders that was filed and talked about the importance of affirmative action in the military. And that did reportedly have an impact on certain justices' votes. It was certainly discussed at oral argument. And the point that I'm making is that's an example of a point of view that was expressed during the course of this entire procedure we've been talking about that influenced justices one way or the other, and that impacted the outcome. So the fact that you're prejudging how you're going to judge something can almost commit you psychologically, where you've already, it's called an endowment effect, where you think you've already kind of committed to something, and you overvalue that particular thing as a result.
Right, and there's also an accountability problem, Renato. So this is an unsigned order. I mean, we know that 3 justices, the liberal justices, dissented. So we know that the other 6 are on board. But there's no reasoning. There's no, justice that is, signing their name. There's no concurring things. And, in a normal opinion, you would have everybody explaining exactly what their reasoning is and sort of having some accountability. I mean, sometimes there's per curiam opinions where it's not, on any one justice, but where each of the justices stand. And this one, you kind of just don't have that accountability. And I think this, by the way, this line really stood out to me because this goes to another factor. I mentioned the likelihood of success on the merits. Another factor is whether the injunction, without an injunction, it will cause irreparable harm. So we talked about this with Harvard. Like, if you allow this thing to proceed, is this going to harm the party in such a way that you're not going to be able to remedy it later? And the court says the stay also reflects our judgment that the government faces greater risk of harm from an order allowing a removed officer to continue exercising the executive power than a wrongfully removed officer faces from being unable to perform her statutory duty. I found that really extraordinary.
It's definitely counterintuitive, and it tells you, I think it's revealing about how the majority of the court thinks about executive power, right?
Yes.
It basically is anyone other than the president of the United States, in this sort of this almost more unitary view of executive power, exercising executive power is itself some sort of non-tangible. It's non-physical, but it's sort of it's a harm. It's a more theoretical, but a harm to our system of government, and that outweighs these 2 women, Miss Wilcox, Miss Harris, losing their jobs, and then theoretically having being then reinstated in them when this decision would be rendered fully in the future.
Yeah, Justice Kagan writes in the dissent, this order puts the president over precedent. And I think that is a good way. But we haven't even gotten to the punchline, Renato.
Okay, I can't wait now. So tell me, Asha, what's the punchline?
The punchline is, after going through all of this, the court does this weird carve out for one particular agency.
Yeah,
for the Federal Reserve.
That's true.
And says, it goes through this whole thing about the president's ability to, hire and fire, and this applies to even bipartisan independent agencies, or it's likely to apply, this precedent. And then it says, and the respondents say, well, this would, if you were to overturn Humphrey's executor, this would obviously also impact the Federal Reserve, which then has the potential to wreak havoc on our economy, because if the president can hire and fire Federal Reserve board members at will, this can be really damaging. And the court says, without explanation, yeah, but none of this applies to the Fed.
Well, it's a unique one-off explanation, right? Like, it's like when you're talking to your kid and they're like, why? Well, it's, you come up with some reason. I said so, essentially. It's not one thing they do give a hint of where they're going here, where they say, quote, the Federal Reserve is a uniquely structured, quasi-private entity that follows in the distinct historical traditions of the first and second banks of the United States. So what I foresee in my crystal ball, we'll see, one theme today is you can always, all these episodes end up coming back later, right? And there's threads that come later. I think that they're gonna find some penumbra in the first and second banks of the United States, some historical hook that could say, well, this is the one example of something that can be carved out of this general rule. And it's all because in 1790 or 1800, there was something called the first or second and the second bank in the United States.
And weirdly, that happens to coincide with protecting their own investment portfolios.
Asha, a former special agent in the FBI, a Yale professor of national security, and Renato, he's a former FBI agent and also a leading lawyer, white-collar criminal defense lawyer, another civil litigator. And they come together in a show called It's Complicated. You just saw a clip related to the Supreme Court stay and what it means for a 90-year-old precedent we like to call in the business Humphrey's executor. If you like that and you liked Asha and Renato, you're going to love the channel. Legal AF, the channel, YouTube, in collaboration with Meidas Touch. Hit the free subscribe button as we continue our march to 700,000 subscribers with your help. We've got Legal AF, the podcast, on the Meidas Touch Network, and then we bring it over here for another run so we can have one-stop shopping for all things law and politics here on Legal AF, and then Legal AF, the Substack. Subscribe to it all. It's free for now. And we appreciate you helping to build our audience, our fellowship, speaking truth to each other so we can speak truth to power. So until my next report, I'm Michael Popak. I'm Michael Popak, and I got some big news for our audience. Most of you know me as the co-founder of Meidas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popak Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popak Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popak Firm today at 1-877-POPAK-AF or by visiting my website at www.thepopakfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popak Firm, fighting for your justice every step of the way.